Hello, I'm Cameo George, executive producer of American Experience, PBS's flagship and longest running history series. Thank you for joining us. Today's Past Forward conversation exploring the power of the Supreme Court in shaping our nation's laws is inspired by our new film, Sandra Day O'Connor, The First, now available to stream in full on our website and in the PBS video app. Sandra Day O'Connor, the first, is the story of the Supreme Court's first female justice. During her 25 years on the court, she was the swing vote in cases involving some of the 20th century's most controversial issues, including race, gender, and reproductive rights. From Roe v. Wade to Citizens United versus the Federal Election Commission, American politics in the modern era have been shaped by landmark Supreme Court cases that have fundamentally changed the laws of the country. But should the Supreme Court be so powerful? And when did legislating from the bench begin? We'll talk about that, plus how a single justice's rulings can impose law through court instead of through Congress, how Sandra Day O'Connor and other justices have exemplified this, and what this ends up meaning for people fighting for legislative changes today. As always, this is meant to be an interactive conversation. I invite you to write questions in the chat box. We'll answer as many as possible during the discussion. Before we begin, I'd like to acknowledge our corporate sponsors, Liberty Mutual Insurance and Consumer Cellular. I'd also like to acknowledge the Alfred P. Sloan Foundation, the Corporation for Public Broadcasting, the Robert David Lyon Gardner Foundation, the Documentary Investment Group, PBS, our home station, GVH, and of course, viewers like you. Now, it is my privilege to introduce our panel for this conversation. Evan Thomas is the author of First, Sandra Day O'Connor, the New York Times best-selling biography that inspired our film. Kimberly Robinson is a Bloomberg law reporter covering the Supreme Court and co-host of the Cases and Controversies podcast. This conversation will be moderated by Monica Munoz Martinez, professor of history at the University of Texas at Austin. Thank you again and enjoy the conversation.
Thank you, Cameo. Welcome, Kimberly and Evan. It's great to be here with you today. Let's kick off our discussion with some core questions about the role of our nation's highest court. Let's start with the basics. How are laws meant to be enacted in this country from a layperson's perspective? What is the constitutionally intended role of the Supreme Court in our justice system? And a pressing question that's circulating widely is, what is legal precedent?
Sure. Well, I'll take that one, Monica. Thanks so much. I wanted to say first off that it's really great to be here with you and Evan to discuss, Justice Connor and the importance of the Supreme Court, particularly as we see, the Supreme Court is in the news a lot. So I think it's great to be able to discuss these issues. As far as your question, enacting laws really falls to the political branches, that is to say Congress and the president. Of course, Congress debates and passes the law, and the president has a veto power, but otherwise, signs the law into force. And as for the judiciary and the Supreme Court, the Constitution actually says very, very little about its role. But we've seen the court since its earliest days really carve out a role in this kind of lawmaking process through what's known as judicial review. And that's really just the ability to determine what the laws that are passed by Congress and the president, what do those laws mean? And something really important that comes along with that is the ability to strike down any federal or state laws that violate the Constitution. And so that's really the way that the judiciary interacts in this lawmaking process. And, it's an important one. And you also asked, what is legal precedent? We have so many fancy words in law, but it's a really simple idea that the law shouldn't change frequently and radically. There should be some stability in the law that allows people to go about their everyday lives without having to worry if something that they're going to be doing is going to be later interpreted to be illegal or against the law. And so, courts tend to try to keep the law pretty stable. But that's not to say, of course, that the Supreme Court is forever bound by its previous decisions. And I think Plessy versus Ferguson is probably the best example of this. This was a ruling back from the 1800s that, said separate but equal was okay. And of course, that's not the law of the land today. It was overturned in Brown versus Board of Education and other cases that followed. But this idea about when it's appropriate to jettison precedent is something that the current justices are really debating, and it's going to be really important to an issue I know we're going to talk about later, abortion. And as the court gets ready to answer whether it should overturn Roe versus Wade, and it's the following case, Planned Parenthood versus Casey, which of course is one of Justice O'Connor's most consequential decisions.
Great, thank you. Evan. Mm-hmm.
Well, all through history, there's been a tension in the Supreme Court about how active they're going to be. We've gone through periods where the court kind of laid back and didn't do much of anything, deferred to the legislature, and was sort of quiet, so to speak. And other periods where the court was incredibly active and gave real meaning to the Constitution. The famous period that most people think about is the Warren Court in the 50s and 60s, where they took the 14th Amendment, which had been around since the Civil War, or the end of the Civil War, and they gave it new meaning about equality, equal protection under the law, and due process. Those words, due process and equal protection, they sound kind of legalistic. What do they mean? Well, that was the basis for desegregating schools and giving women rights, gays rights that they did not have before, cutting back religion in the public place, no prayer in schools. I mean, big consequential things, and most famously, abortion, giving women a right to abortion. There's nothing explicit in the Constitution that says that women have a right to an abortion, but the Supreme Court gave them that right. That's a big active move. Now, when the court goes too far, in some people's view, there's a tendency to dial back and to pull back, and we're probably in one of those periods right now. But there's a lot of controversy over this because Supreme Court justices are not elected. They're appointed by the president and confirmed by the Senate, but they're not elected, and they're there for life.
Great. Thank you both for it's important to think about the historical context of the Supreme Court and making decisions that impacted people's lives in the 1890s, throughout the Jim Crow era, and certainly during the era of the Warren Court. And it's especially interesting to think about Justice Sandra Day O'Connor and the era in which she had incredible influence on the court. She was the first woman on the Supreme Court nominated by Ronald Reagan in 1981, a pioneer who both reflected and shaped an era. In her 25 years as justice, she was a swing vote in cases about some of the 20th century's most contentious issues that we've already been speaking about, including race, gender, and reproductive rights. So, Evan, tell us about Justice O'Connor. How did she approach her opinions? Was she more interested in interpreting the law or making the law? How concerned was she with maintaining the proper role of the court within the judicial system? And I guess more specifically, what was her interpretation of the proper role of the court?
She was what they call a minimalist. Her idea of being a good judge was to do not more than is necessary. She did not like sweeping opinions. She did not like overreaching. She was also sometimes called a consequentialist, meaning she was very sensitive to the consequences of what they were doing, particularly unintended consequences. Courts can sometimes, with broad language, have all sorts of unintended consequences. And she was very careful about that. So she was cautious, she was careful, she was a check on power instead of somebody who reached for power. On the other hand, and this is where this tension comes up, as the first woman on the court, she was sensitive to the rights of women and to the rights of the downtrodden and the dispossessed. And although she starts out as a conservative, as a Goldwater conservative, she's appointed by Ronald Reagan. As time goes on, she moves somewhat to the left, and she becomes the author of two very important opinions, which are now, this very moment, being tested. One, preserving affirmative action in higher education, and the other, the right to abortion, women's right to abortion. She modified those things, but she preserved them. And of course, they're now under attack. So even though she's known as a cautious minimalist, she actually has her name on two big decisions that are under attack by the Supreme Court right now.
Great, thanks. Kim, did you want to add anything?
I mean, I think Evan knows the most about Justice O'Connor, but I think that is really one of the great things that, this film really shows is, how she tried to balance, these kind of competing concerns that she had, this concern of not wanting to do too much, but also being really sensitive to, as Evan put it, the downtrodden.
Great. Let's watch a clip from the film that exemplifies her approach.
Early in Justice O'Connor's time, her second year, a case comes before the Supreme Court, a very important case in gender discrimination.
We'll hear arguments next in Mississippi University for women against Hogan.
A man wanted to attend the Mississippi University of Women nursing school. It was close to where he lived. It was a public university, but it was only for women.
One of a series of cases strategically brought to challenge gender discrimination and thereby expand women's rights. The Hogan case struck a particular chord for O'Connor.
Mr. Golson, you referred to the demand for a single-sex institution as being its justification. Would you make the same argument if there were a demand for an all-white, publicly funded education?
At the Supreme Court conference, the vote is tied. 4 justices say yes, 4 justices say no. As the junior justice, O'Connor has the last vote. It's up to her. She's the 5th vote to let men in.
O'Connor was assigned to write the opinion for the liberal majority.
O'Connor ruled that the exclusion of men from a nursing program was based on stereotype, and it couldn't stand as a matter of equal protection under the Constitution. That showed the world that, although she had never presented herself as a feminist, that the first woman on the Supreme Court was going to make a difference when it came to sex discrimination.
Then, in a move that would become a kind of signature, O'Connor narrowed the ruling to the facts of the case.
She added a footnote saying that this decision would only apply to the nursing school, even though all of the reasoning of the opinion on its face applied to any university. It was the narrowest possible holding.
She regarded that as the appropriate approach for the court to take. You decide the issues that the court accepted. That's the way that the court moves the law along.
Justice O'Connor did not think that it was the role of the court to create revolutions, to lead reforms, but rather to serve as a limited check on the powers of government. If change is to be had, it is to be done through the legislative process.
So her judicial philosophy was, you don't know if you're going to do harm or good if you make too large of a ruling. Make the narrowest ruling to resolve what you have in front of you and stay within the sweet spot of America's belief system.
She was a very effective politician well before she was appointed to the Supreme Court. And she had faith in that democratic process and the votes of the people.
Am I wrong in thinking that your experiences in the politics and law of Arizona more strongly shaped your constitutional views than being a woman?
Oh, I don't know. I leave that for other people to say. I don't know.
But as I read your opinions, I come time and time again upon your reference to the states, much more so than I do any what might be called feminist insight.
I'm a product of state government, and I think that it is appropriate that we try to preserve strong and capable state governments, because I still tend to believe that the best government is that government closest to the people.
On the really tough cases, the big social issues like affirmative action and abortion, religion, Justice O'Connor's view was that the Supreme Court is not the last word.
Nothing's ever settled on this court for sure, is it?
No, it's never an absolute end to any issue. It's more a process of a continuing dialogue.
Dialogue between
the court and the Congress and the nation as a whole.
This clip speaks to O'Connor's view that the Supreme Court is to act as a limited check on the powers of government, and that their rulings should never be the last word or absolute end to an issue. I think this is such a central clip from the film. Evan, was there any elements to that film that clip that you wanted to speak to?
There's a great modesty to Justice O'Connor's view on this. We're not the last word. People think of those judges in black robes, that there's like gods. No, she didn't believe that. She really believed in the idea of the dialogue between the different branches of government. This should be reassuring to people who think the Supreme Court has too much power, because the problem is that although she does talk about it in the clip you just saw, and she talks about it, I think, with Bill Moyers, she didn't really talk about that in her opinions. She didn't really articulate her own judicial view. And this is a problem because it's possible to be too modest. She worried after she left the court that her impact was waning quickly, because I don't think she did it as much as she might have, clearly articulating the very point of view you heard on that clip. It's really not in her opinions.
Kimberly, could you tell us, what do you think of O'Connor's view in today's political and social climate? I mean, to Evan's point, if there were more opportunities where in writing we had that clear view in precedent, in decisions, has the Supreme Court gained power over time, and why? What are the implications for shifting power from one branch to another? And is the O'Connor tradition long gone? Tell us what your thoughts are.
Well, I mean, I think this idea of who makes the law is still very much an issue that the justices today are debating. And you can see it playing out in some of the two biggest cases that are on the court's docket for this upcoming term, which starts in October, and that's abortion and gun rights. And so in both of these cases, we have a state legislature that's put restrictions on a constitutional right. So with guns, New York placed restrictions on who can carry a gun outside. And with abortion, it's Mississippi that's placed a ban on all abortions after 15 weeks. And the question in both cases is, what can the state legislature do, or what can it not do? And I think it'll be interesting to see, these are very nuanced cases, obviously different parts of the law, but I won't be surprised if the justices come down differently in those cases. That is to say, some might think it's okay for the state legislature to restrict guns, but not abortion, or the other way around. But the fact that the Supreme Court is weighing in on these otherwise state decisions just shows you the power that the Supreme Court has come to have. And I think it's really important for people to know it's not just in these really hot button issues. It's on the cases that garner a lot less attention as well. The three cases I can think of that the justices are also going to decide are how much power federal agencies have to regulate healthcare, whether or not states have to include religious schools in any student funding, and even what the signs on the side of the roads and highways are going to look like near you. So, I think we tend to focus a lot on these really consequential and contentious issues, but, a lot of the small stuff really matters too. And they're deciding, who has the power to tell you what you can do.
Thanks. You're right, and I think we should continue to speak a little bit later on what's on the agenda upcoming. I want to think a little bit about some recent decisions or indecisions by the court in other ways. Roe versus Wade and the recent Texas law banning abortions at 6 weeks is all over the news. This decision came out quickly with no oral arguments or signed opinions as part of something called a shadow docket. Shadow docket rulings have shaped policy on several issues related to public health, immigration, and access to civil rights. So, Kimberly, what is the shadow docket? Why are more cases being decided in this way, and particularly those that impact millions of people? What are some examples of decisions of rulings that have been made, shadow docket rulings?
Sure. So I'll start with, what is the shadow docket? It's a very gloom and doom kind of term, but really it's a name that a law professor came up with to describe really anything that happens off the court's normal docket. So when we think about cases at the Supreme Court, we think about, months-long briefing, from all sides and a lot of different parties, oral argument in the courtroom, and then a long, detailed opinion or opinions really laying out why the justices came to the ruling that they did. The shadow docket, or at least the part that's received the most attention lately, are emergency requests that are brought up to the justices by one party or another. And these cases are decided in days, not months. There's no argument. And there's often very little explanation from the court beyond maybe a sentence or two. And, one really odd thing that I find about covering the Supreme Court is sometimes in these shadow docket cases, we don't even know which justices ruled which way. So we have to say things like there were no noted dissent. That can be frustrating for people who want more transparency and really want to understand, why the Supreme Court has come to such a big decision. But it's tricky because, there have to be a way for justices to decide emergency applications. And I think the most obvious example are, the shadow docket is full of requests related to upcoming executions. And you want there to be a way for the court to step in and stop an execution if there's some kind of problem in the process. But I think the criticism has lately come in part that they seem to be using it to intervene in more cases that in the past they probably would have just allowed the lower courts to sort out and kind of eventually rise up to them. One example is, it's probably no surprise that there have been many, many emergency requests related to COVID restrictions that have been put into place, everything from voting to mask mandates. And all of these decisions have played out on the shadow docket. We haven't had any that have come through the court's, regular process, even though, this pandemic is now coming up on 3 terms. So I think that's a really good example of how really important laws that affect us all are being decided, and, some of the problems that people have with that.
Thanks, Kimberly. It really sounds like you're describing that the shadow docket expands the court's ability to shape American society. Do I have that right? And a follow-up question is, you're a reporter of the Supreme Court. And so for there to be questions that you have, and it really raises a question about transparency. Does the public deserve more transparency into this process, especially when cases impact people's lives on a national level? I mean, I'm so thankful that you're giving us an understanding of the role, especially for emergency decisions. But what you're speaking to raises a lot of interesting questions about transparency and if this is an expansion of the Supreme Court's ability to shape American society.
Yeah, I do think that, this is a really important way. And I think that Texas case that allowed, Texas's 6-week abortion ban to go into effect is really one of the best examples of that. Even before the court had issued the ruling, the law was allowed to go into effect simply because the court literally didn't say anything. And the court's inaction meant that the law went into effect in Texas. And it wasn't until the next day that we got a ruling from the court. But by then, abortion clinics had already turned away some people. And, even when we got the court's reasoning, it was just a single unsigned paragraph that didn't really explain, some of the questions that people had. And that was actually the point of Justice Kagan's dissent in that case. She specifically called out the court for its use of the shadow docket to decide, these monumentally important decisions in such a hurried way. And I think one of the other criticisms that we hear about the court is that it's not using the shadow docket consistently. So, for example, in this abortion case, there were some procedural quirks about the law that were deliberately put there to make it harder to challenge this law in court. But then there had been an earlier challenge to a COVID restriction on religious gatherings. And despite procedural hiccups there, the court decided to lift those restrictions anyway. And so again, these are very nuanced cases, lots of reasons why the cases could have come out differently, but we're just left to guess about that because we don't have a really considered opinion from the justices explaining why it was okay for the state to act in this one way, but not in this other way.
It's really quite chilling. Evan, Has the expanded use of the shadow docket experienced any opposition amongst lawmakers? And what is the rationale for moving forward in this way, despite any opposition?
Well, the rationale is these are emergencies that they have to be resolved. But the Supreme Court is, it's at its best when it takes its time. And one of the good things about the Supreme Court is generally what they do is pretty public in the sense that they, their arguments are open to the public. They have to write opinions where they justify their decisions. I spent a lot of time in the archives of Justice O'Connor, and I think people would be glad to know that the argument between the justices, even the private arguments, are very principled. They're not political. It's not log rolling. It's not like Congress. They're not swapping favors. It's very intellectual and legalistic, but that takes time. And if you do something quickly, it immediately people start to think, well, the Supreme Court likes to say they're not political, but they are. And it's a problem for the court's legitimacy, which really does depend on the perception that they're not totally political. If they're doing things hastily without justifying what they're doing in a kind of reasoned and legal way, people start to think, yeah, they're just a bunch of, well, to be crude about, they're hacks. They're not that. That's of course not what they are. But that's the argument, is that if they do things too hastily and if it's too obviously political, that undermines the court's legitimacy. So I think the dissenters in that abortion case, Kagan and others, they were right to say, wait a second. We got to be careful what we're doing here. The worst example of this is a case a lot of people remember, Bush v. Gore in 2000, where the Supreme Court basically elected or allowed the election of George Bush in a very fast, rocky case. It was a per curiam decision, which means it wasn't signed by anybody. It was just the court. The reasoning was widely criticized. And even the people, including Justice O'Connor, who played a fundamental role in this, felt badly about it because it made the court look bad. And at the end of the day, she wished that they hadn't taken the case at all.
Well, let's talk about the current Supreme Court. President Trump, while in office, appointed 3 conservative justices, but Barrett and Kavanaugh so far have voted more in the Roberts camp, which seeks to be nonpartisan and lean into cross-ideological rulings. The only exceptions so far where justices have ruled on party lines seem to be on voting rights and business regulations. Kimberly, can you speak to specific voting rights and or business regulation cases where conservative justices have used their majority to vote in a certain way? I mean, this is bringing us back out of the shadow docket and just thinking about, the regular procedures. But can you speak to specific cases that would be helpful to think about voting lines and how they might shift depending on the issue at hand?
Sure. I think at the outset, before I give an example, I think it's important to be careful to say here that the justices last term did not always line up in ways that we would expect, and there was some crossover votes where liberals were either able to win or at least limit the damage. And I think most notably we can see that in the court's ruling in the latest challenge to the Affordable Care Act, or better known as Obamacare, where the court rejected kind of these broad calls to gut the entire law. But there have been some really, really notable examples, as you suggest, in particular in a voting rights case that came out of Arizona. And this was a challenge to some specific voting laws, but the outcome of the case with regard to those particular provisions is less important than how the court got there. And that's because the rationale that the justices used in that case are going to apply to all kinds of future challenges to voting rules. And those, of course, are being pumped out in the states currently at a very rapid pace. So they're going to be looking to this case. And what happened there was, the court split 6-3 with all the justices appointed by Republican presidents, setting a pretty hard test to be able to challenge these laws. And the 3 justices appointed by Democratic presidents saying that the test should be easier. So, we did see a lot of these crossover votes last term, and I think we'll continue to see some of them. But, this upcoming turn is really when the rubber hits the road, I think. There's so much on this thing: abortion, guns, religion, and even affirmative action. And these are all those kinds of cases where we expect to see the ideological splits, really hold on.
Great, thanks, Kimberly. And two other really pressing issues are of course, regulating pollution and the fight for climate change. So what implications might pro-business rulings in this next session have for President Biden's plans, to regulate pollution and to fight climate change?
Yeah, I mean, I don't think we have to look too far to see, how these kinds of decisions from the Roberts Court affect things like climate change. So the Roberts Court under Chief Justice Roberts has been seen as pretty pro-business. And I think, with a very broad stroke, that's correct. And what that's meant for environmental regulation is that the courts made it easier for businesses to challenge those regulations while at the same time making it harder for the public to hold companies liable. So just last term, we saw a case in which the city of Baltimore is suing BP and other oil companies related to climate change. And the court ruled in favor of the oil companies who are trying to get the case heard in federal court rather than state court, which tends to be a bit more hostile. I think, since we were talking about the shadow docket, one of the wildest cases that I've covered since I've been, covering the Supreme Court is one that came off of the shadow docket in an environmental case, and it involved President Obama's plans to limit carbon emissions. This was the Clean Power Plan. And in 2016, the justices, took the unusual move of granting one of these emergency requests and halting the plan while it was being litigated. And just a few days later, Justice Scalia died. And if the ruling had been 4-4, then the Clean Power Plan would have been allowed to go into effect. As we have it, the Biden administration is still trying to figure out how to regulate these greenhouse gases.
It really does just sound from this conversation. I mean, there's a series of questions about transparency, especially with related to the shadow docket. As a historian, I love to hear you both talk about the opinions and the dissenting opinions. Students in my classes, even high school students, are able to read these opinions, and I think that they're great and crucially important historical documents. I also just am so curious to know Evan's thoughts about what Justice O'Connor's thoughts and views of the current Supreme Court would be. You spoke a little bit about, her shifting position on the court. And so I'd love to think about, or to hear from you, tell us a little bit more about, whether we should expect justices to vote according to their political beliefs or reach across the aisle to reach more bipartisan decisions. It's not a new belief, but it does feel so far out of reach. So what would Justice O'Connor tell us? And maybe you want to give us a little bit more insights into what you think actually pushed her to shift course in different moments.
Well, one of the sort of great things about Supreme Court justices over their long life is that they do evolve. Some of them evolve a lot, all the way from the right to the left. Famously, Harry Blackman, Justice Brennan was kind of a surprise. I mean, they do. They can surprise you. And Justice O'Connor did move to the left. She started on the right and she moved to the left. You can measure that in a number of ways. I once asked Justice Stevens, John Paul Stevens, I said, do you think that Justice O'Connor moved to the left? And he said, yes. And I asked, really, why? And his two-word answer was Justice Scalia. She was reacting to Justice Scalia, who was a bully and a right-wing bully. And so personalities do matter. Scalia did bully her or try to bully her. She's a hard person to bully. So that matters. But this is important. She didn't love that. But she was somebody who tried to bring the court together. And she did on numerous occasions. She was able to find a middle ground to compromise. She was the one justice coming out of the state legislature. They're all now out of federal courts of appeal. She's the last justice to come from the political world. And she understood compromise. She had to learn it in the Arizona legislature, where it's hard to do. And she was on a number of occasions able to get the judges to actually compromise, get along with each other. That was her view of how the court should exist. I remember Justice Thomas telling me that when he got in the court, he was lonely, feeling beleaguered by his confirmation hearings that were a mess. And she kept saying, Clarence, you got to come to lunch. You got to come to lunch. And he said, okay, finally he did. And he said it changed everything for him. Once he started coming to lunch with the other justices, he learned how to get along with them. And it made a difference. These personalities do make a difference. And if they hate each other up there, it's bad for all of us. And if they work together, it's better. It doesn't always work. They're dealing with tough issues, and yes, they do disagree, and sometimes pretty vigorously. But Justice O'Connor was very good about having a unified court, and he gave her power. In 1999, she was only in dissent 4 times. The court, I can't remember how many cases they decided, but 100 or something like that. She had real power because she occupied the middle and she knew how to use that power.
Great, thanks. I want to make sure that we have plenty of time for questions from the audience. So this is the last question. I'll start with you, Evan, and Kimberly, if you can add after Evan. The court's next term starts in October. Roe versus Wade and affirmative action are 2 of O'Connor's biggest cases. They're on the docket. So what are the different possible outcomes for these rulings? And Kimberly, I'd especially like to hear from you. What else should we be looking out for in the next term? And are these issues better decided in Congress than in the court? I mean, here we are sort of waiting for October to see what's going to happen. And it comes back to this bigger question of, the role of the Supreme Court and what it should be. So Evan, what do you think are the possible different outcomes for these rulings on Roe versus Wade and affirmative action?
They're big, and there could be big change here. On affirmative action, Justice O'Connor wrote a case called Grutter about 20 years ago, upholding affirmative action in higher education, meaning racial preference in admissions. I think this court, there's a good chance they're going to knock that out. They're going to say no more racial preference. It has to be colorblind, because the Chief Justice in particular on this says the way to get past racial discrimination is to not practice racial discrimination. So he's hot on this, and I think he's going to be able to find 5 votes. So I think this is going to come as a rude shock on campuses everywhere, which have become accustomed to affirmative action and believe in it. They're going to be surprised and unhappy about this decision if it happens. I mean, this precedent is hard to overcome, and they may work around it. On abortion, I think it's also possible to have a big one to actually overturn Roe v. Wade after all these years. They've been whittling away at it. That's Justice O'Connor is part of this. She in the Casey case in 1992, she got the court to enact something called undue burden, saying the states cannot put an undue burden on a woman's right to abortion. That's kind of fuzzy. What does undue burden even mean? And the states have been pushing and pushing and pushing. And now the question is, how far will the court let them go? They do listen to precedent. Roe v. Wade is a pretty important precedent, but there's a chance they will knock it out. And so that will mean that abortion will return to the states. State legislatures will decide whether you can have an abortion or not. I don't know if that's going to happen. Kimberly, you're more up to date on this than I am.
Yeah, I mean, I think, before the Texas abortion case, I would have said it was unlikely that they were going to outright overrule Roe and Casey. They'd probably kind of come up with some way to limit it. But after the Texas abortion decision, I think my mind has been changed a bit. And that's just because, in the Texas abortion ruling, they were very careful to say, we're not making this decision on the merits. We're not saying that this Texas law is constitutional, but just that there was a procedural problem. But we've seen procedural problems before. They're not unique to this case. And we've seen the justices overcome those procedural hurdles when it's a right that they really cherish. And so I referred before to a case where the justices, kind of overlooked some procedural problems in a case challenging COVID restrictions for religious gatherings. And so to me, I think their refusal to do so here kind of says something about the importance that they hold, or at least some members hold the right to abortion to be. So I guess we'll see if that's correct. Of course, reading the Supreme Court tea leaves is always a dangerous game, but I do think that's a real possibility.
Great. Well, we actually have some questions from the audience that I want to get to a little bit out of order, because one is a great follow-up to that last point, Kimberly. Joseph on Facebook wants to know, Kimberly, can you talk to us about what it's like to cover the court as a journalist? What are the challenges that come with it?
I will say one of the biggest challenges that comes with the court is that they like to say that they're the most transparent branch of government. But frustratingly, I will disagree. They often will tell us, there's some opinions that are coming down today, but we won't know what they are. Oftentimes we get lots of opinion at the same time, and we're trying to write these really important decisions quickly and all at once. It was interesting the other day to hear Justice Barrett gave a speech in which she criticized the media for really not doing a good enough job of explaining to you all what the justices are actually doing and getting all the nuance in there. I do think there's a lot that the court could do to kind of alleviate that, to make themselves more available to us. It's pretty hard to get them to talk to you. They kind of stay locked behind their gates in the upper floors. But I do think transparency is probably, one of the most frustrating things. That said, I love covering the Supreme Court. It's really great to go into that majestic courtroom, to hear, so many really smart people debate these topics that are really important. It's terrific. And frustrating.
Transparency, it sounds like, access. Okay, this next question is from Mark from YouTube. Evan, he asks, what were O'Connor's contributions to areas that not so much in the social and political sphere, but areas such as patent or regulatory processes?
I don't think she had much of an impact on either patent law or regulatory law. That's not where she left her mark. I don't think that was a particular of great interest to her. She was, a somewhat right of center. So on regulation, she would be sensitive to upholding state legislatures, but I don't think she left her mark in either of those areas.
Okay, great. Jean on Facebook wants to know, do you consider anyone on the current court to be similar to Justice O'Connor in terms of the way they interpret the law?
Nobody exactly like her. Kagan is political and occupies her old chambers, actually, and I think sees herself in a bit of O'Connor's role of trying to keep the court together and find the middle. I think Roberts has O'Connor's sensitivity to how the court looks to the public. O'Connor is, although he's conservative, Roberts, although he's conservative, famously in upholding Obamacare. I think that was a political case where he just didn't want to have the Supreme Court knocking out the work of Congress and doing something so radical. So he found a legal way to preserve it. That was a bit of a disappointment to conservatives. But I think that shows Roberts' sensitivity to the appearance of the role of the court. I think, and that's something that she cared about. I think it's something that they were friends, actually. Something that I think that a lot of justices care about, but those two in particular do. But somebody looking for the middle ground, not so much.
Kimberly, I saw you nod your head with the reference to Justice Kagan. Do you see similarities also in your reporting?
Well, I do agree with that Justice Kagan is probably the closest one, but I think in an important way, there's no one like Justice O'Connor on the court today in that, there's no swing justice. And, somebody who might, swing from different sides of an issue to another. We're going to have cases where there's going to be a middle ground, but that doesn't always mean that that's, in the middle of, right and left. It just means that's in the middle of where the current court is. And I just don't really see a justice that swings in the same way that O'Connor did or even Justice Kennedy did. And, we'll see that come up not only in the rulings that come down, but also the cases that we hear, that we're going to be hearing a lot more conservative cases at the court. And so even if those aren't successful, it'll be interesting to see, that they pop up on the court's docket. And these are kind of the issues that they're debating.
Evan, Sarah on YouTube wants to know, where would O'Connor find herself today on the issues of reproductive rights and affirmative action? Would she still be pulling the court towards the center or continue to make room for small government?
Good question. I think on different outcomes. I think on affirmative action, she and Grutter said, we expect that in 25 years, we will no longer need racial preferences. I think we're in year 18 or something. And I think she might go with Kennedy on this, Roberts, Chief Justice Roberts, and actually vote to do away with affirmative action in higher education. I'm not sure of that. It would be hard. Actually, she wrote Grutter. That's her own opinion. And she very much saw the importance of affirmative action in producing leaders in law schools, that law schools and the military, she thought, need to look like America. So 25, I asked her about this, and she said, well, I may have been too optimistic about the timing. So I think she might actually go the other way on this. On abortion, she would, I'm almost sure, vote to preserve Roe v. Wade, a women's right to an abortion. Even though she had her doubts about the decision about Roe v. Wade early on, was in dissent in a couple of times in the 1980s, looked like maybe she was voting to overturn it. She went the other way, and I'm pretty sure, it's hard to read her heart, but I'm pretty sure that having written Casey, she might allow the states a lot of leeway on undue burden, but she would not vote to overturn Roe v. Wade.
It's interesting to think about, watching the film, that 25-year limitation certainly struck me. As somebody who has worked on different universities and campuses, there's still a lot of work to be done for these institutions to be, fully inclusive, and so it is such an interesting year. I wonder what guided that 25-year mark.
Just to contradict myself here, she might be persuaded. She was persuadable. She's somebody who listened to the facts. She actually read the record. She wasn't doctrinaire. So if the arguments were made in a persuasive, factual way, just what you're saying, hey, there's still a lot of work to be done on campus, that could persuade her. She was persuaded. I mean, she was voting against racial preference in cases in the 1990s. She was on the other side, and she came around to support affirmative action in Grutter. So that was a shift for her. And, if she saw a good argument, if you were arguing the case and you made a good argument, she would actually listen. But I sense in her the kind of impatience here. She also she's an old-fashioned integrationist. She liked bringing the races together, and she would be upset by racial division on campus. That is something that would offend her, bother her. Now, maybe she learned to understand it, and she'd be, modern about it and try to understand it because that was her nature. But I know that she would be bothered by it.
Monica, if I could just jump in here, I wanted to make it clear for, people listening that, the court hasn't yet taken up the affirmative action challenge. It has asked the federal government to weigh in on whether it should take it up, and they're going to be filing a brief soon. So this is something to look for in the future. But I do suspect that if not this year, next year, that it will reach the court and the justices will decide on it.
I think it's notable that they're kicking it down the road. The very fact that they asked the Solicitor General for a brief, that is a punt. They are stalling here, trying to put some distance between a pretty hot summer of a year ago and where I think they're going, because they know how unpopular it's going to be if they actually do vote to overturn affirmative action and higher education. They know that's going to be unpopular, and they want to put some time between the events of a year ago and that. And I'm guessing at this, but I just sense it.
As a historian, I tend to think about the court today in a much longer historical context. And so I'm glad that so early on we were thinking about cases like Plessy versus Ferguson. Philip on YouTube has a question about public perceptions of the court by different groups of Americans. And wanting to know, he says, the public perception of the court by different groups of Americans has shifted across history. Is this an arc towards justice, or is it a political ebb and flow as the court leans more to the left or more to the right?
Well, that's the eternal question, isn't it? I mean, that is the great question. What is your view of history? Justice O'Connor's view of history was something as archaic, known as the Whig view of history, that things get better, that rights are vindicated, that the history of the United States is a gradual one step forward, one step back. Boy, we had a lot to overcome after slavery. I mean, and the work is not done. But, there's a general evolution in the direction of vindicating rights and towards justice, broadly speaking. That is an optimistic view of history. That was what Martin Luther King said famously, the arc of history bends towards justice. I think Justice O'Connor had that view, but there are a lot of people who don't, who think that things just swing back and forth. It's more like a pendulum, and you can have dark periods. I mean, there was something called the Dark Ages, that lasted for hundreds of years, centuries. And I know there's a view, particularly among some younger people who are worried about, or rightly so, about climate change and a lot of things, that we're entering a darker time here. People worry about democracy, the future of democracy. I think Justice O'Connor would be one. And that's not the Whig view. I don't know what to call that, but it's a pessimistic view that things are not forever destined to get better, but that they can go in reverse. And in there are parts of the world they have.
Yeah, I think it's not directly answering the question, but I think it's really interesting. One thing that I've been watching are polls, opinion polls on how people think that the different branches of government are doing. And, the Supreme Court has been, pretty high in people's minds, I think, in recent history, but we're seeing that fall pretty sharply and across the board, really, not just with young people or old people or left and right. A new one just came out today saying just 30-something% of people approve of the work that the Supreme Court is doing. So, as much as I think the justices care about public opinion, I'm not sure that they're doing a good job fulfilling kind of, what people think they should be doing.
That would really upset Justice O'Connor, that drop in that number. I mean, there's a basic turning away from institutions generally. I mean, you look at polls in the early 1960s, 70-80% of people believe in the press, Congress, business, the military, the church, you name it. Today, 10%, 20%. There's been a turning away from all institutions. That is, it could be the potential of a new and better age, but it also could be a harbinger of dysfunction and chaos.
Well, to that point, in terms of public perceptions of the court, and it certainly was something that Justice O'Connor was very concerned about. But to think about language here, Marilyn on Facebook asks to please address the partisanship and judicial philosophy. Is there an actual difference today?
Are they more partisan? Is that the question? Then,
well, is there a difference? She's saying, is there an actual difference today between partisanship and judicial philosophy?
Oh, that's a great question. This is the question that was posed by Justice Barrett just this weekend. She was saying, "Hey, you're making a mistake here. You think we're being partisan or political? Actually, we have different judicial philosophies, and that's not the same thing. There's overlap. Judicial philosophies can be different than partisanship as we understand it, left, right. But there's a lot of overlap. I mean, it happens to be that, originalists and structure and textualists happen to be conservative, and people who believe in the living Constitution and that kind of activism happen to be on the left. So there's definitely overlap between judicial philosophy and partisan belief, but there are also differences. And you can get some odd results, like Justice Gorsuch upholding something. Help me here, Kimberly. It was the way. I think it was Title IX or federal civil rights law was applied to sex, and you would think if he's a conservative, he's not going to be for that. But no, he was a literalist. He's a textualist, and so his judicial philosophy led him to a liberal result. So that can happen. Justice Scalia was big on criminal rights. Who knew? Because he read them literally. The Sixth Amendment, if you have a right to confront the witness, he means it. So you can get these kind of funny results, but they're the exception. Basically, I hate to say it, but you can pretty well predict, not totally, but you can pretty well predict how the court's going to come out on these big social issues in terms of their partisan beliefs. I don't like to admit that, but that's just a fact.
Yeah, I think actually that was exactly the example that I was thinking of with Justice Gorsuch, and that, it's really his judicial philosophy that led him in that case to apply, federal anti-discrimination laws to cover LGBTQ workers. And so, that isn't a politically driven agenda but is driven by his ideology. But I think Evan's right that a lot of times those two things really do overlap. And I think, for all intents and purposes, they often feel like they're the same. But that is exactly what the justices mean when they say they're not partisan hacks. They don't think of themselves as Republicans and Democrats. They think of themselves more as originalists or constitutionalists or textualists.
Great. Well, we're running just a few minutes left, and I want to try to get to two more questions. We're getting a lot of questions about term limits and the size of the court. What changes would you make to the court to strengthen its impact in American government, or do you think it's effective as it is? Who would like to respond to that? What changes would you make? Would you expand it? Would you restrict some of the?
I want to hear what Kimberly thinks about this, but I would not expand it. Well, I think that's chaos, invitation for disaster, a big mistake to pack it, because then you really politicize it. So that's about it. Now, this question of term limits, that's a more complicated question because medical advances have made us live longer. And so you can kind of hang on longer. And I do think maybe justices should retire. I don't know when or how that would work, but I don't think they should just live until they serve until they drop. I don't think that's good.
Yeah, I mean, I've been watching Supreme Court reform very closely. There's a presidential commission on it, and we hear a lot about packing the court. I think one reason why it's so popular is that it's actually something that Congress can get done. A lot of the other things, there's some questions about whether or not term limits would really be constitutional. But there are other changes I think that this can be made to the Supreme Court. There's things like limiting the kinds of cases that the court can hear, or requiring the justices to come to like a supermajority if they overrule legislation, smaller reforms. But I do think that, this issue of what needs to change, if anything, is something we're going to be dealing with in the next couple of years.
Great. Well, to bring it back to O'Connor, we've got one last question from Carrie from Facebook asks, it seems that one of O'Connor's signature moves was narrowing the case and creating loopholes for later decisions to make changes. Maybe you talk about the strength or the weakness of that, and is that a guiding practice for the court as it is today?
Well, the good part about it is don't be too, modesty is a good thing. And being humble is a good thing, and a humble role for the court is a good thing. Deferring to the other branches of government, that's always good. And also to be careful about the consequences. So those are positive things to being a minimalist, as we call her. What's not so positive is it's sometimes understand what the hell they're doing. I mean, if it's just the facts, well, what does this really mean for other cases? If it's just the facts of this case, how do lower court judges know what that means when a slightly different case comes along? So it doesn't give the clear guidance that lower courts especially look for from higher courts. Also, it makes it more kind of fungible and ephemeral. I mean, we were talking earlier, O'Connor felt some of her things were just being blown away. Well, maybe she didn't do a good enough job of kind of buttressing her own arguments, I think is the argument. She gets criticized in law reviews for that, and with some reason. I by and large, obviously, am sympathetic to her and to her approach, because I like, there's a famous line from Learned Handed Judge who said, the spirit of liberty is the spirit that's not so sure it's right. And that is a healthy thing for lawmakers and judges, to not be so sure you're right. We live in an age, people are very judgmental, very moralistic. I'm right, you're wrong, particularly in social media. A little humility, it goes a long way. And Justice O'Connor was a confident woman, but she was humble too.
Yeah, Monica, I think, an example that can really kind of bring home some of the issues that can come when, a case is very fact specific is a case called Masterpiece Cake Shop, where the justices considered, whether states or a cake maker can be made to make a cake for a gay wedding, even though it's against their religious beliefs. That was a very fact-specific ruling. The court kind of looked at the facts of that case and sent the case back down. And it's an issue that's still percolating around the lower courts, and there's no answer yet. And so we see it not just in cakes, but in flowers and pictures and all over, and we don't really have an answer. And so that's one of the ways that it can make it difficult. But we'll see how that comes out.
Yeah, we'll certainly be paying attention and looking forward to October. Thank you, Kimberly and Evan, for joining us today. We're out of time. Here's Cameo George with closing remarks.
Thank you for joining us today for this very timely Path Forward conversation. Sandra Day O'Connor, the first, is now available to stream in full on our website and on the PBS video app. You can watch our Path Forward conversations anytime on our YouTube channel or on our website. If you liked what you saw today, please go ahead and hit subscribe on our YouTube channel and sign up for our events newsletter. You'll be the first to know about new conversations, including our next one exploring the evolution of news, journalism, and our relationship with the media, inspired by our upcoming film, Citizen Hearst. Thank you again.